Today, we are talking about common hazards and who is responsible in occupiers' liability claims. So if you've been injured by a hazard on someone's property, today we're going to talk about who could be responsible under the Occupiers Liability Act. I'm Natalie Gary, the principal lawyer and founder of Gary Law. I help injured people get the compensation that they deserve for their injuries. Let's get into this topic. So first of all, common hazards that lead to claims are things like stairs, sidewalks, parking lots, and aisles. Property owners, and especially occupiers of property, have the obligation to make sure that these areas are reasonably safe. Accidents often happen when there's ice, uneven surfaces, poor lighting, tripping hazards. This can be things like maintenance that hasn't been done properly or renovations that haven't been completed fully so that there's kind of debris laying around or stairs that haven't been fully finished. For example, a pothole in a parking lot could be a hazard if it causes someone to trip, depending how long it's been there, how big it is, and various other factors. This is a gray area, so it is important to get legal advice about what actually constitutes an unreasonable hazard. Another example is poor lighting on a stairway that could hide a broken step or a hazard. This could be considered something that a property occupier would be liable for. Some other hazards to watch out for are the common causes of slip and fall accidents. These are primarily ice and snow that hasn't been remediated or removed. The snow hasn't been removed, the ice hasn't been treated with any de-icer. Uneven pavement and broken steps that can also cause accidents frequently, and poor lighting in areas that hides potential dangers. Also, slippery surfaces like wet or waxed floors that do not have warning signs. For example, if you've seen a wet floor sign that's there to warn you of a hazard, then that is an indication of an occupier trying to mitigate the hazard there. But just putting up a wet floor sign doesn't mean that the occupier isn't responsible when someone slips. It really depends on all of the circumstances and what is going on with that sign, how visible it is, the area it's put in, also how slippery it is, what the person who slips was doing. There are so many factors that go into determining liability. You might be wondering who might be liable if you're injured on someone else's property. So claims like this may involve various parties like landlords, store or hotel owners, restaurant owners, even the people renting the property if they are responsible for the maintenance. And sometimes even private homeowners can be liable. It's important to include everyone who could be liable because compensation could cover pain and suffering, lost wages, lost ability for housekeeping, medical bills, and expenses associated with rehabilitation, and more. So an example of this is if someone falls outside of a restaurant because of icy stairs, both the restaurant and the property owner might share liability. So depending who was responsible for maintaining those stairs, if it was a joint responsibility, then they might both be liable. It is important to get advice from a personal injury lawyer on these issues so that you know who to name in a lawsuit. I can be contacted at the information below, and I would be happy to chat about your particular circumstances.